Good afternoon, everyone. Welcome to the FSBPT's webinar, The Times They Are Changing, Optimizing Regulatory Effectiveness and Investigation through Discipline. I'm Michelle Thorman, joining you from Wisconsin on a beautiful fall day, and I'm pleased to introduce our group of panelists who are coming to us from Kentucky, Stephen Curley and General Counsel Keith Pointer, from California, Jason Kaiser, and Deputy Chief of Bureau Investigation, Ken Garcia, and from Oregon, Sherry Peru. I did a little survey before we started today, and these folks represent a collective 81 years of investigative experience. I can't think of a better group than to take on this important, timely discussion. Jason, would you like to take it from here, please?
Sure. We're going to be using Slido to get some participation out of you as participants in this matter. We got a pretty simple one for you to start with. We want to get you signed up, so please take out your cell phones or what you need, your tablets, scan the QR code, and that will get you set up. First question is pretty easy. It's a type-in question. Let us know where you're joining us from. All right, seeing a good assortment. We're just shy of 100 people in the room today, and we've got about 30% of you reporting. Man, Wisconsin is here in force. So we're at about the 50% mark. We have a few minutes for you guys to get downloaded and on board. And again, just please type into the screen where you're joining us from. I have a few more people that are actively entering. Here we go. We have chats. We have a couple letting us know where they're from in the chat. And that'll work well. I'll try to represent that and keep an eye on it too. Okay, so we are on to the next poll. So now that we know where you're from, let's try to figure out what each of you are doing here. What's your role? And so you'll have a multiple choice. Please select that now. All right, so we've probably got 3 or 4 in the chats contributing, right around 53. It's pretty safe to say at this point now, probably half the room are investigators, which is what we were hoping for. So that's a good thing. So FSBPT asked a few of us to kind of come forward and expose all of our flaws in model so you guys can learn from us. And so we reluctantly volunteered to do so. So I think in California, the enforcement model, the process in and of itself is fairly simple, as you can see from the slide that's on the screen. I don't know why anybody would call that overly complicated. So if we could focus in a little bit across the top, it starts very similar to, I think, that how anybody's enforcement model would, with just that generated complaint. It moves down through that process into an investigation, and from that investigation, if we could go one more animation, from the actual investigation into the actual administrative process and a final disposition that we're trying to attain for our consumers. I present this slide just to show you that actually it is an overly complicated process, but It doesn't have to be complicated. It can be very simple, and it can be very artful, in fact. So the next slide, if you don't mind. The Physical Therapy Board of California is housed underneath the Department of Consumer Affairs. And one of the things that the Department of Consumer Affairs provides to us is an actual law enforcement agency called the Division of Investigation. And I have a deputy chief from the Division of Investigation with me here today, Ken Garcia, and I'm going to be passing it off to him in a minute. But what you see in front of you is what we consider kind of our priority matrix, right? So this is the guidelines, if you will, to determine when we receive complaints where we think where it becomes appropriate that we involve a sworn peace officer as part of the investigation. If you animate one more slide forward. So obviously some of our most egregious complaints, those of sexual misconduct or the unlawful use of narcotics and prescriptions, gross negligence, injury to some of my patients, practicing while under the influence of a mind-altering substance, those kind of things really fall into that category 1 urgency. And then again, a little bit lower than that, some of the issues that we have, aiding and abetting the unlicensed activity issues, criminal violations, actions that may not necessarily have occurred during the work hours of my licensees, but certainly speak to their ability to have sound judgment or to act safely. But that's not a really hefty load of our investigation cases. If we move one more down into the animation, you'll see that we have complaints in categories that are investigated by my board staff, our desk investigators, and then just keeping in mind those complaints as we receive them can almost dance, if you will, from one category to another. They may seem very egregious upon complaint, but through some investigation, you find out there's not that much there, and vice versa, right? They can come in as a very kind of mundane complaint and then escalate up.
Oh, cute.
There's a huge portion of our complaints that my staff, my investigators, have responsibility for, even up until involving that sworn peace officer portion of our investigation. And that's the part that I wanted to speak to a little bit. Even within California's Department of Consumer Affairs, the Physical Therapy Board of California's model is just slightly different. Ken will probably touch on it as well. And that is the relationship that we have with the Division of Investigation. Anytime that some of our cases fall into that category 1 and category 2 priority matrix, and we send out a sworn peace officer, we also send out one of our own licensees serving as an expert consultant with the board. So there's a very collaborative approach in that investigation where we have the knowledge and the core training of an investigative mind, but we also have an expert that goes with them that can kind of explain the definitions and those things that are related to the practice of physical therapy. And with that, I'll kind of hand it over to Ken. Ken will take the next slide that describes our actual complaint investigation process a little bit more precisely.
All right. Thank you, Jason. As he mentioned, my name is Ken Garcia with Department of Consumer Affairs. We are the law enforcement branch, being the Division of Investigation. Just some background, we were formed in 1961 through the state legislature to be an essentialized investigative services for our department. There are over 36 boards and bureaus that we service. We provide criminal and administrative investigations for. It regulates over 3.4 million licensees in the state of California. So it's more than 250 professions and occupations, from physical therapists, nurses, acupuncturists, veterinary, security guards, and a few dozen others. Like Jason said, I mean, a lot of our success comes from this robust relationship that we have with our boards and bureaus. We provide excellent client services to them. And it really is, like you said, it's a dance. Nothing is static in our world. Depending on the facts of the case, we're constantly updating the board and determine how to best proceed with an investigation or handling of a complaint. So what I'm going to touch on here really is a more condensed version of what you saw on the first slide. This is our complaint investigation process. Typically, a complaint comes in to the boards or the bureaus. Could be from anywhere from a consumer complaint, general public, sometimes an outside law enforcement agency that may not have the technical experience or expertise to handle these types of cases. The board typically gets the case, the complaint, looks at those prioritization guidelines that we just showed on the prior screen, and kind of determines from there, one, do they have jurisdiction over the type of complaint? And is this something that either can be handled internally with the board, or should it be forwarded out to the division investigation for a sworn peace officer to handle? As you can see here in the green area here, that's kind of the first part that I had mentioned, trying to determine where it goes first. If it does come to the division, it comes to the blue section here. If you want to follow the flow chart, we have an internal case management system where the board will send us what we call an RFS, which is a request for service. This includes the type of complaint it is, the complainant's information, suspect's information, and any witnesses, any kind of documentation that the board may have received. That comes to the division, and we have investigative analysts that receive that. Our analysts review the complaints, any associated documentation, reviewing for thoroughness, sometimes requesting additional information if it's available, and may do some initial workup for us before it gets sent out to a sworn peace officer to investigate. Once it does get to an investigator, it depends on where the incident occurred at. We have a field office throughout the state of California. So once it gets sent to them, we conduct an investigation typical to any investigation, whether it be criminal or administrative. Interviews of witness and subjects, gathering documentation, serving search warrants if it's criminal, subpoenas if not, undercover operations, stings. We have computer forensics team that we also utilize as another technique for some of our investigations. And again, nothing is static. Sometimes the case facts lend to something that between Jason and I, we have a discussion. If it's better handled in the lane of the board, then that case can come back and is adjudicated through the administrative process. Otherwise, it does stay with us. Criminal investigation, we reach out to the local district attorneys or sometimes the state attorney general's office, and even sometimes through the federal partners, Homeland Security or the FBI, depending on the significance of the case. And kind of just following through with the flow chart there. Ultimately, everything goes back to the board. Whether our case is filed criminally or if it's administrative, it goes right back to the board for a proper adjudication. As you can see on the left part of the chart, it does talk about our attorney general process and administrative hearings and proposed decisions and stipulated agreements and such. And then ultimately, everything comes back to the board for determination on how to take action on the individual. And again, I can't stress how important it is to have this relationship with our board partners. It's what brings success to us. We do have work alongside our board appointed experts. This really helps in terms of being a consult for us regarding the laws or regulations investigators may not be familiar with, helps us formulate interview questions and subjects and witnesses. We have clear delineation of duties for inspections that we do out there with board experts. So it's critical to the success of not only our function, but also the board. And obviously with the same end goal of public protection. So it's been a awesome experience working with the board, and we continue to do that for all of our boards and bureaus within the Department of Consumer Affairs. And with that, I will turn it over to the next slide, which will be Oregon.
Hi there, I'm Sherry Peru. I am a physical therapist and I am the clinical advisor and investigator for the state of Oregon. The Oregon Board of Physical Therapy operates very differently than California, much smaller, a number of licensees, And we're a semi-independent state agency, and we have 8 board members and 4 staff members. So very small board, very small staff. I have been the investigator here for 22 years. I'm a physical therapist, and I was hired because they used to use an outside investigator, and they used to use a board member to do their investigations. And when I came on board, they decided it would be nice to have one person be able to do the job without having to pull in board members to do the investigations and without having to have an outside investigator. So having said that, I came in as a PT. So I had to go through quite a bit of investigator training to learn the investigation piece of it, but I do have the clinical background, which as far as I know, I think there's maybe one other state that has someone in my role that is a licensee of the board, and I find it to be very, very beneficial, especially when I'm interviewing licensees. But having said that, all of our staff, our executive director, Michelle Sigmund Gaines, and our licensing coordinator, and our data analyst, all of them have gone through the minimum of the basic investigator certification through CLEAR. Michelle and Sarah have gone also through the specialized and been certified as investigators. And I think that's really important, because having a very small staff and having one investigator, I'm actually surprised it hasn't come up until very recently that I had to do an investigation of somebody who I knew. And I didn't feel comfortable doing that investigation, and we had to call in another investigator to do it. And so we call Sarah, our coworker, did the investigation, and she's a trained investigator. And it made me think about, like, several years ago, I was at, I think it was it could have been an FSBPT or maybe a FARB conference, where it was a FARB conference where there was a speaker who was from Nevada, from the mortuary board. And she was telling this story about doing an investigation, and that the executive director had to do the investigation because she had a conflict of interest as the investigator. And what happened is the person who did something pretty egregious came back and said, when it went to hearing, hey, the investigator who did the investigation is not trained, and this person doesn't have the skill to investigate me. And then I believe it went to the Supreme Court, and the case got thrown out because of the skill of the investigator. So we've actually gone through the effort to have everybody in our staff trained. We've also had all of our board trained in trauma-informed care. We're doing a lot of work here in our state, just looking at boundary complaints and things like that, and trying to get all the board trained. We can move to the next slide. So next time I'll know I can make a really cool, complicated chart to go with our investigative process, but it's pretty simple. We get our complaint gets received, we either take it on an online portal, telephone, mail, or many of our complaints are initiated by board staff. Those are complaints that would be like people who didn't renew their license and continue to practice, or continuing education, or applicants who failed to disclose something on their application. I review all the complaints and determine if, based on the statutes and rules, there's any potential violations. And if there would be a potential violation, we open a case, assign a case number. I then obtain records and conduct interviews. Sometimes I get an expert physical therapist to come in, maybe one of the board members or somebody who may be an expert in a field that I am not, for example, like pelvic health. And then I write a report. I bring that case to the board meeting, and then our board votes on the case. After that, when the board votes, I communicate back to the licensee and the attorney regarding the vote of the board. And then our cases can close with either no action, a non-disciplinary advisory letter, a stipulated agreement, which I think in some states they call it a consent order, notice of proposed disciplinary action, or a final order, or a hearing followed by a final order. Someone's asking in the chat, who authors the written communication back. I work with our Assistant Attorney General, so between me and the Assistant Attorney General, we draw up the legal documents that go out to the licensees. One thing that I want to mention is our board members are not part of the investigation unless I need to bring a board member in. And if I bring that board member in for an investigation, then they don't vote and they're not part of the process of hearing out the case when I bring it to a board meeting. And our board is also not part of the hearing process. So in the hearing, it would be myself and our board AAG who's representing the board. And then if we had to have any expert witnesses, I speak to a lot of different administrators and investigators in different states. And it seems like the majority of states, the board members are a little bit more involved in the hearing process and maybe even the investigative process. Next slide, please. And I just wanted to pull up this slide. This is just since 2001, we've had 786 cases, 622 licensees, 20 compact privilege holders, 113 applicants, and 31 unlicensed respondents. I know some states can investigate unlicensed practice and have a little more authority over unlicensed practice than actually we do in the state of Oregon. But I wanted to highlight somehow the orange number disappeared off the slide, but most of our cases close with either no violation or an advisory letter, or and then there's I'm trying to add the percentage, 30-something% are closed with action. I wanted to highlight the compact privilege holders because I'm going to talk about that a little bit further on in the presentation about communication between different boards and how important that is, because the more and more people that start obtaining compact privileges, the more we have to communicate with other states and figure out where are these people coming from and what is the other state where the person is licensed, what are they doing, and are they investigating it, and how do we work together to do that. Next slide. Just going to see if there's someone asked, where are the results published, and are they easy to find? For our case in Oregon, they're published on our website. And so you can search by name, or we also have a list of disciplinary actions on our website. I believe California has that because I've looked at it. And I'm not sure about Kentucky. I'll let Stephen talk about that. So we'll move on to Kentucky now.
Yes, my name is Steve Curley. I'm the executive director with the Kentucky Board of Physical Therapy. That's a role I've been in for a couple of years now. Before that, I was an investigator with the state for 13 years. I was a private investigator for 4, and then 13 years with the state for about 12 different boards in my time. So I'm going to talk a little bit. One of the boards I worked for during that entire about 13-year was Kentucky. So I'm going to talk a little bit about Kentucky's complaint process that I worked as an investigator and now obviously oversee as the executive director. So we don't have the flashy department that California has. This was done by, I met him at a gas station around the corner. But as you can see up at the top, we receive complaints. So we have a variety of different ways we receive complaints. The most common is initiated complaint, where we have a signed complainant. But the board has the ability to initiate their own complaint, a board-initiated complaint, or BIC. We have renewal complaints, CE violation complaints. So we have a variety of different complaints that could come in. But however we receive the complaint, the process is pretty much the same. So we receive a complaint, information that the board deems warrants an investigation, and they open an investigation. The complaint is sent to a complaint committee. And this is a group of 2 of our board members. Generally, it's our board chair and 1 other member in a rotating status. We have a new board chair every year, so they rotate off and we get a new one. They are the only ones in the board process, which Keith will talk a little bit more about. Keith is our attorney, and he's also on this presentation. He'll talk a little bit more about the confidentiality process that we use in Kentucky to keep information kind of limited. So the members of the complaint committee, the 2 members, are board members, physical therapists or PTAs. They see every piece of information. The board will only see complaint numbers. They won't see people's names, and the information they receive is limited because I believe it's Sherry that was talking about their board members don't necessarily sit on hearings. Ours can sit on hearings. It's kind of our choice. We either use a hearing officer or a panel of board members. So the complaint committee reviews, they make a recommendation to the full board. The full board opens an investigation. We assign a complaint number. The board or the complaint committee's determination is if everything in this complaint is true, is it a possible violation? If it is, there's their duty to open an investigation. They open it, they assign an investigator, and we move through that process, which we'll talk about in a bit. If they determine that there is no violation of KRS 327, then they close the investigation or they close the complaint at that point. Obviously, the vast majority of our complaints that come forward fit into the category that they could be a possible violation. So we open an investigation, appoint an investigator. The case manager is almost always me. I supervise all the complaints. I issue subpoenas. We collect documentation. And then what happens is I turn all that information over, including the response, the complaint, and subpoena documentation to our contract investigators. And they're broken out regionally throughout the state. So that's how they get assigned. Once we get that process, the investigation starts. If the investigator needs additional subpoenas, the office will issue them, and we move through the complaint process or the investigative process. So our 2 contract investigators are former law enforcement. They have no ties to physical therapy. They've done this for quite a few boards in the state. Their job is not to determine, obviously, guilt or innocence. Their job is not to determine that something was done wrong. Theirs is to collect facts and turn it over to the board who makes that determination. At that point, once the investigation is complete, a report comes to the complaint committee. They make a recommendation to the board to either close the case due to insufficient evidence or move forward with charges, which we get to this point. The forward with charges process, we generally try to settle our cases, I think like most states. But if we need to go down the line of a formal board hearing, that's the process we'll go to. And you can see on the right there the insufficient evidence portion if the board decides that there's not enough evidence to warrant an investigation or to warrant charges moving forward. And then as far as closing the case, settlement agreements, private admonishments, discipline, suspension, revocation, same as everybody else. And then we publish the board outcome. So we publish it both through FSBPT to the HIP National Practitioner Data Bank. We also publish it on our website through license search, but we also have a page that's actions, has the most recent from the last year as far as disciplinary actions. If we have to go to a hearing, we'll bring in an expert if the board needs additional information. Like Sherry said, if there's a pelvic floor case, not a lot of our board members are pelvic floor, or pediatric case, we have a list of expert witnesses that we would bring in to provide additional information to the board. So that's kind of our complaint process there. Go ahead and next slide. So we have another poll question. So if you want to get out your Slido stuff, and the question relates to, in your state or wherever you're working, what investigation model do you most have? Is it California, who has that large scale, Oregon, who's a little more independent, but a little bit bigger than Kentucky, or Kentucky, who's fully independent, but is a lot smaller? I don't know, jumped out there. And I don't know is interesting because I noticed in the early poll, there was a lot of people there was a lot of investigators, but there may have been a lot of people that weren't tied. And when we talk about this stuff, like Sherry said, it's important, if you're a supervisor, if you're in the process somewhere, if you're a board staff member, that you are aware of how your investigations work and how they're supposed to work, especially if you're a supervisor, so that you can make sure they're running appropriately and you can help make changes if those changes are necessary. You have to know how it works to be able to kind of tweak it, because, you know, I've been doing this for a long time, and I'm sitting down right now to try to figure out a better way as a supervisor to do things to make sure my investigators get things timely, because we have that process where, like Jason said, where we have urgent cases like sexual misconduct cases or boundary cases, and maybe a little bit less urgent like fraud and material deception that are important, but we don't put them as high. So how do we manage those, and how do we get them quicker? I think we've got only about half the people answering at this point. Okay. Well, we're going to move here to, I guess, me again. Actually, Keith, if you want, I believe you're the first portion here. If you want to step in and introduce yourself.
Sure. Thanks, Stephen. My name's Keith Pointer. I'm general counsel for the Board of Physical Therapy. I've been doing this role for the Board of Physical Therapy for about 4 years now. And prior to that, I was general counsel for the Board of Chiropractic Examiners. It's a part-time job. Traditionally or typically spend most of my full-time hours working in civil and criminal litigation. I'm a plaintiff's attorney and a criminal defense attorney. So what we wanted to talk about was my category is there on the left, and I can help with Stephen as we speak with both sections, but we talked about the confidentiality of the complaint system. It's critically important when you're handling an investigation process, when you're presenting information to board members, or in our case, the complaint committee, to do a really good job to try and sanitize the process so that the potential respondents are not identified. I've worked places before where they won't necessarily know the person, but they may know the major metropolitan area where the complaint's coming from. And sometimes that even something as innocuous as that might color the opinion of the people who are evaluating the facts of the allegation. So it's really important to make sure you do your dead level best to keep the complaints confidential, so you can get an objective view of it. During the investigations, all of our, as in Kentucky, as probably is the case in most states, everything's subject to open records, but during an investigation, the open records process is not available because it's a current active investigation. So we keep everything locked down, and none of that information is available to the public or to anyone else. I mean, certainly a respondent has discovery ability as a case proceeds through the process, but by and large, for the most part, we work really, really hard to make sure that everything stays buttoned up and kind of close to the vest. Then after the investigations, you know, all the documents, as Stephen has said, if we have disciplinary action that we're going to take against a respondent, then that goes on our website. We produce all that information to the appropriate databases and things of that nature. But you have to be very, very careful about what you release, so as not to release PHI, you know, things of that nature. So, you know, the takeaway that I would give for everyone involved in something like this with respect to the confidentiality is it's important in all three phases. It's important during the early outset as the complaint's coming in. It's important during the investigation, and it's super important after the investigation. So just be mindful of that as you go through there. Stephen, we can talk about the pitfalls now that we see from investigations. And if you want to jump back in here on that, I'm happy to yield the floor to you. But
yeah, well, and anything you have, Keith, you know, feel free to jump in here. So the goal of this kind of webinar is to create hopefully interest, to kind of get an audience, and the goal would be to have additional webinars to expand on some of these. So some of this stuff I'm going to go in pretty quickly through, and if it is something, you know, something that I'm talking about, Keith's talking about, Jason, Ken, Sherry, any of us are talking about that you have additional interest in, please PT know, because we would love to kind of expand on this. And like I said, the goal is to have a series of webinars if there's interest. So some of the pitfalls that I wanted to talk about relate to, you know, civil cases, obviously malpractice cases, We get a lot of those here in Kentucky. And the issue at hand is, or the pitfall there is that you can easily be used if you complete your investigation, if you go investigation, you can be used as a target or a piece of evidence in the malpractice suit pretty easily. So generally what we do here in Kentucky is when we get a complaint that's ongoing, we try to let the civil case resolve itself, because we have done investigations when it's been kind of an urgent matter. And what happens is then we have to fight to stay out of the civil case, because we always get drawn in somehow, either one side or the other. If you prove that somebody did something wrong, you're obviously going to be on the plaintiff side. And if you prove that nothing happened, the defense is going to try to call you. So that's kind of a tricky spot. You have to weigh, the urgency of the matter versus getting drawn into it. And if it's not a super urgent matter, let's try to wait it out. Criminal complaints, same way. Obviously, when criminal complaints come in, especially we've seen an influx of criminal complaints for boundary issues. Your goal is, there's obviously some urgency there with criminal cases, or some criminal cases, not necessarily all of them. And you really want to push forward with the investigation, but you meet a different kind of roadblock. And that's the roadblock of guys like Keith not wanting their clients to talk to you. So that's where you run into really quick. I saw Keith come off mute, so I'll let him.
Yeah, no, exactly. We've had cases in the past where, there are folks who've been charged criminally for things that have happened clinically. And, while there's a huge, boundary violations and the like, and while there's a huge rush to want to get in there and investigate your administrative case so you can show that you're being proactive, the defendant or the respondent in the administrative case, the defendant in the criminal case, they have rights. And so, there's not been an instance that I've had where the defense counsel hasn't said, I'm going to make a motion to hold this in abeyance, where the hearing officer or a judge or anyone else wouldn't agree with that because of the obvious, rights against self-incrimination. So something to be cognizant of. It's frustrating from the administrative side. Your cases will stay open longer when you're dealing with something like that. But in the long term, that's kind of how you have to handle it. At least that's how we're doing it.
And then the next one would be types of complaints. So, if you have a boundary complaint that's not tied to a criminal case, there's certain complaints that require you to push forward faster, like Jason talked about, those kind of urgent complaints that really require you to move quickly, because especially somebody that's received some sort of, trauma from their care from a physical therapist, when you move quickly, when you complete that investigation quickly, it shows that you're taking this matter seriously. I know one of the suggestions that always comes up is have kind of a zero tolerance policy on your website for boundary complaints. And as a state agency, that's not really a thing that we can do without getting in a lot of trouble from our legislature. But what we can do is complete these quickly. So our boundary investigations, from the time we have a piece of paper in our hand to our investigation complete, is about 30 days. And, we keep track of that, how long it takes, and we know we can get it done. Because then if we have to go to hearing, once we turn it over to hearing officer's office with the Attorney General, we don't have control over that process and how long it takes, so it slows down. So we do the best we can with the process we have, depending on the complaint. And then, like I said, time is, talk about a little bit, time is the same thing. Even if it's a low level one, how long does it take? We keep track of that, which I'll talk about really quickly on the next slide. And then costs. I always look at that. Investigators, how long do they take? Is the cost reasonable to the investigation that's occurring? What can we do to maybe lower that cost to credential holders? Because you got to kind of look at that too, is are we being cost effective, especially if we're getting our costs back from the credential holders at the end of the investigation. Next slide. So talk about data for a little bit. It looks like we had some questions. Keith, if you want to read the chat, maybe you can.
Well, it says, in New Hampshire, we still request the licensee to speak with our investigators. If they refuse, which it is their right, it will be taken as an adverse inference. The Fifth Amendment isn't really applicable in administrative law. And, I can't speak to New Hampshire law and how you all are handling, that particular type of an issue. I can tell you that we don't, we absolutely don't make a negative inference based upon someone's right to remain silent. There may be case law out there that from New Hampshire specifically that I'm not familiar with, but here in the Sixth Circuit, I would not feel comfortable with that. If to the extent that that's how it works for you, I guess that's a good thing. I would not advise our board or any board where I was counsel to participate like that. So, I mean, if it's working for you, then it's working for you, and certainly follow the advice of your own counsel. And I'm not sure, Mr. Porter, you may be counsel. It's just not the experience that we have.
Yeah, and as far as an investigator from that approach, I'm sure none of the investigators in this chat has ever had somebody they were interviewing lie to them at any point. But I would treat somebody that refuses to talk or incriminate themselves the same way I treat somebody that I think is lying to me. And that is, I'm going to collect evidence to prove that you're lying to me. And sometimes it works out and sometimes it doesn't. So it just really depends. I would probably treat that person the same way. If you're not going to talk to me, that's fine. My job is to collect evidence that proves your guilt or proves your innocence one way or the other. And that's what I work on. So just talk a little bit about data. I know we got a couple other questions, I think maybe coming in, and we'll take a look at them at the end here. But data is another issue or another thing that comes up that investigations that it's easily overlooked, and I think is an important part of investigations, and a bit of it I already talked about. But we keep track of timelines, how long it takes from when we get the complaint to when we open the investigation, how long the investigation takes, how long it takes for us to get charges filed, how long it takes for us to get a hearing, how long it takes for us to get a settlement, investigative costs, outcomes, whether they're closed, settled, whatever, types of complaints. And all this information together can really give you a picture of how your investigative process is moving. Is it moving in a good process moving forward? Is it sluggish in certain areas? Can I address this? Are certain investigations costing more money? Now, inherently, documentation related courses like fraud and material deception are going to cost more money, but are certain ones taking more of our funds, or are we having to recoup more from? And it can really show you patterns that you can then make adjustments to your investigative process. Okay, it's taking too long for us from the end of the investigation to filing charges. How can we speed that up? Specifically that, because if you say, I want to speed up the whole investigative, you kind of lost in the sauce there. There's so much to do. You don't know where to turn. But if you focus on one thing, you can make changes there and make successful changes to help your process move forward. But it can also show bias. It can show, my board disciplines individuals stricter for these types of complaints. Why? Is it because we take these more seriously, or is it because there's an inherent bias there that needs to be adjusted? So data is really important, and I could talk about it for quite a while, but there's a lot of different aspects of the investigative process that you can collect data and then make changes to your investigative process. So as far as where we publish results, so our results are published on our website. So our license, you can search individual PTs and PTAs. If they've been disciplined, it'll be under there. But we also have a section called disciplinary actions that have it's on our navigation bar. It has all the people that have been disciplined in the last year on there. So that's where we publish our results.
The last thing I'll say on this, and we'll hand it off to Sherry. You're welcome, Michael. I know you said you guys debate that internally as well. I would tell you, as someone who does criminal defense, my advice to anybody, if you think that there might be the possibility of being arrested, your license is fine, but your license does you no good in prison. If you think you might be arrested, my advice to you would be not to speak with anyone, certainly not anyone from the government. So that's the last bit I'll say on that, and I'll pass that off. Sherry, it's all yours.
Thank you. Couple of things I want to say. So I'm looking, we have 97 people in this presentation, and in listening to everybody talk and looking at the chats and people asking questions, I am so excited that we have at least half of this group are investigators. I don't think I've ever been in a room with this many investigators unless I was in an investigator training class. So it makes me really excited that investigators wanted to be here and that that we all want to collaborate. I mean, I've been involved in the Federation for a long time, and I feel like I've had the advantage of when I go to an annual meeting or I go to a committee meeting, something, I get to talk to people, and that's how I get to know people in different states that I can call and say, hey, how are you guys handling this? Or I have a complaint here that deals with this. But honestly, most of the people that I talk to are administrative staff when I go to meetings. So just a little plug for investigators to go to the annual meeting, to participate in webinars and to be involved, because it would be so great. I mean, I know Stephen really well from both of us being investigators for a long time. Jason and I are on committees, but it would be really great to have, and we're going to talk about this some at the end, like, how can we all somehow get to know each other? Because yeah, it's going to be different. The way they do it in California is one way. The way they do it in Kentucky is a different way. And the way we do it in my state is the way we do it here. But we're all still investigating complaints. And we know that people move, right? People don't stay in one state. Also, we know that people live in places like Oregon, where Washington is right, 5 minutes across the border from where I am right now. And if I lived in Southern Oregon, California is really close the other way, and Idaho's this way. So how do we all communicate with each other when someone might have a license in different states and not just moving, might just be working in one place one day and another place another day? So I'm going to talk a little bit about the Physical Therapy Compact. Right now we have 30 states issuing compact privileges. Compact states are required to report open investigations to the Compact Commission. And compact states must report a disciplinary action to the Compact Commission within 14 days of that action. And then we get a notification that says, hey, this person's under investigation, or hey, this person's been disciplined. So that way, if someone has a license or a compact privilege in your state, that they are either under investigation or that they've had a disciplinary action. Important thing to know is once there's an action on a compact privilege, that individual can't get another compact privilege for 2 years. So we just had somebody here who had an action against a compact privilege, but was able to get a license through the licensure process and a complaint that the board initiated. But that person, now if they go to another state, they can't just automatically get a compact privilege. They have to apply for a license in another state. They're going to have to indicate the disciplinary action that they have, and the other states would know. And then also through the ELDD, the Exam Licensure Disciplinary Database, through the Federation, the states share information. So the FSBPT lets other states know when somebody has been disciplined in your state. I'm looking at, and thank you, Michael just left a comment, and I appreciate you sending that comment, Michael, because he said we had a mutual case last year, which I don't want to give too much information, but it was somebody in New Hampshire that there was a criminal case. We found out about it. We immediately had that person agree not to practice in Oregon because they had an Oregon license. I believe Washington did the same thing. And I think there were a couple other states where this person was licensed. And at least while the criminal case is going on, they weren't able to just pick up and move to Oregon because they already had an Oregon license and start working, or then just go across the border to Washington and start working. So all the states really worked very well together to make sure that that person with a pretty severe criminal case wasn't moving all around the country working. A couple of things about concurrent investigations that I want to bring up is I know that Keith talked a lot about confidentiality, and I do think it's important to know, like in our state, everything's kept confidential, but in some states it's not. So if you're going to share your investigative information with another state and they have statutes that say they have to make things public, you want to be careful if you're going to share your information that then it might become public. But I think it's just really important that we somehow learn who we need to communicate with at other states. And I'll be 100% honest. In all the time I've been working here, there's an investigator in California. Her name's Christy. I talked to her yesterday. I said, Christy, can I use your name? I think she's here. And I didn't know there was another level of investigators in California until Ken was on this presentation. And I said to Christy, who's Ken? You know, I've been talking to you for 20 years. And she said, well, I'm the, you know, this one level and Ken's this other level. I did not know that. And same thing, I had a case in Virginia, and I was talking to somebody in the investigative unit, and they said, well, that got sent over to this other unit. And I said, well, who's that? And I thought I was talking to that other unit. They said, no, you're not talking to the board, you're talking to this person. So it really does help to kind of know, you know, how each board works and who you need to communicate with, so that if you have a case where you say, hey, I need to let another board know that this person is also licensed there, or they're working there, and how do I share information with you so we protect the public, not just in our state, but all over the country. Next slide, please. And then we talked a little bit about law enforcement and how do we handle concurrent investigations. In Oregon, we would do the same thing with law enforcement. If there's a case that involves criminal activity, we pass that on to law enforcement, and we usually let them investigate first so that we don't get in the way. What we've been really good at is getting people to agree not to practice while those criminal cases are going on. So at least we know that the public is protected, so they're not working. In my state, I've been doing a lot of work recently with Medicare and Medicaid and passing over some of our investigations to them. They can access a lot more documents, a lot more data, a lot more things than we can, and they have a lot more power over licensees than we do. So do you know in your state, like, how would you send this over to Medicaid, or how would you send this over to Medicare? And then, like I said, do we know how to contact? I feel like I've been really lucky to know administrators in other states, and I can call them. I got a call last week from Charlotte from Louisiana, and she said, can we just talk to you about your investigative process? I want my investigator to talk to you. And that's how I met her investigator, by having a quick conversation of, this is how we do it in Oregon. How do you guys do it in Louisiana? And then now I have a contact person. So there's my contact information there. I mean, my dream is that we go to an annual meeting and there's a like investigator roundtable thing where the investigators all get to meet each other, or we have more meetings like this where at least we get a sense of who is it that we need to call when we have something that we want to work on together, or we have a licensee that we're like, hey, what happened with their license in this state, and we need to talk to them. I'll pass it on to Jason. He'll talk about the ELDD.
Thank you, Sherry. I feel like this is a kind of an opportunity for me, almost like a shameless plug. The ELDD is one of those products that FSBPT has created that I am a huge proponent of. I know there's a few people on this call that have probably heard me speak to it ad nauseum and are tired of hearing me talk about it. Charles Harvey and Corey Tillman Wolf are on the call. They're part of the task force that helped us kind of formulate some of these most recent changes. But to Sherry's point, as government institutions, as law enforcement agencies, we are notorious for not sharing information amongst ourselves. And there's a huge benefit for us to do that. And the ELDD is one of those opportunities that we really can do that. So if we can move to the next slide. Actually, one back. Thank you. So obviously ELDD, examinations, licensure, discipline database. So really the key focus here for you as investigators and the folks that you're preparing your investigative reports for, your board members, the ability to make those decisions and then share that data with other jurisdictions so that they can make very pertinent decisions in determining whether or not that those licensees are appropriate for licensure in their state, or if there are issues or even controls that can be put in place in the issuance of that license. The ELDD helps serve that purpose, right? So you have somebody, as an example, that I may have disciplined in the state of California, who, because of the size of our state and the ability to move from one state to another, say to Sherry's state or to Charles' state in Nevada, to run away from California discipline for that matter, may go to either of those states with the idea of practicing under that license and hopefully And maybe and possibly those other states don't know about what happened to them while they were here in my state. And they would really like to know that. Right? There's always going to be those situations. We just let our imaginations run a little bit, where if you get into a situation where you find the board is in a very controversial situation and comes into the media because of the lack of action in protecting a consumer, you certainly want that experience on your mind when you're making a determination if you're going to issue that person a license in your state. So the ELDD is very helpful for your district in trying to make some of those determinations. Next slide. And it's pretty easy, right? There's FSBPT has been very accommodating for the jurisdictions and trying to determine what would be the easiest way for each jurisdiction to participate in the ELDD, whether it's through assistance or consultation or even through financial means to grant monies granted. They would like all of us to provide to them clean and reliable data so that they can create and house a central database with all of this information that we can all retrieve from. And so here you'll see that we want licensure info, disciplinary actions. Of course, the scores and those kind of things are helpful for all of us when it comes to making some of the more basic determinations of whether or not they're competent and should be practicing in your state. But really that disciplinary action is kind of the focus of what we're talking about here today. And then even to organize some of the data that might come from other projects like the PT Compact. Next slide. Because once that database is created, we can then all rely on it across sections, right? The Federation has gone so far as in collection of that data that, you know, in that example that I gave where I've sanctioned my licensee, the Federation will provide a notification to Sherry and her board and Charles and his board that because they're cross-licensed with those two states, they'll get an alert and a notification that says, hey, your licensee licensed in your state just had an issue in California and has been put on probation or has had their license revoked, right? Very pertinent information, very good information that you would want to consider in the protection of your own consumers. Next slide. And so with that, there are some kind of core components that will help us and assist in forming that database. The FSBPT ID, you know, a unique identifier that is assigned by FSBPT to each individual licensee in the United States so that we don't have to use personally identifiable information such as a social security number or date of birth or those kind of things. We can actually create a tag for that particular person so we all know who we're talking about and we're not confused because we're using very common names like John Smith or something like that. That licensure data, and then again, the most important element in my mind, that disciplinary data. Next slide. So again, shameless plug, if you are aware in your state that you have a less than stellar reputation for sharing information with the ELDD, now is the time to take action. And again, FSBPT will help you every step of the way. And if that is coming up with interfaces and software and systems that will kind of talk between your systems, or if you have issues like I do in California where we're, you know, pressed with very antiquated databases that don't have a lot of functionality, FSBPT has helped us with that as well. And we're not perfect. We're not quite, you know, right where I want us to be, but we're much better than we were before. And then again, if it's a matter of funding, FSBPT has set aside some grant money in that situation as well, and they'll help you with that. So there's really, you know, like I said, this is my opportunity for a shameless plug on behalf of the ELDD task force. Please, if you can contribute to the ELDD and as efficiently as possible, please do so. So I think we have one more slide on. So we'll have a couple following polls. In your situation, who conducts your board investigations? All right. So in Sherry's situation where you have a designated member of the board staff, where Sherry's learned today, I have designated staff that handles that first tier, and then that's that sworn law enforcement branch that handles the most egregious cases. And then even those cases that we heard and we talked about a little bit earlier, where board panels of the board or the whole board in its entirety, the membership, if you will, are actually conducting investigations. Statistically, where do we think we fall in that realm? And this one, I would just say, if you don't know, hazard a guess. You're probably not all that off, right? We were right around 50 and 60 in participation right now. We're a little bit lower on the average. We might have lost a few people, maybe not enough coffee or tea or caffeine, but yeah, so we're right around kind of a quarter that's a mystery, right? Investigators who work for the PT board or umbrella agency providing those services. And then almost 10% that are providing that through the board members themselves. As investigators, for those of you that are on the call, what is your training or background? What brought you to where you are today? Was it work history? Are you former law enforcement? And then what kind of training was provided to you by the board in and of itself? Okay. So I think there's a lot of room for conversation because other is the surprise answer, right? We're going to have to find out what kind of other means. And I'm sure that is some of you have kind of worked your way into the positions you're in, right? You may have worked for that board for a period of time through their licensing staff and then transferred over to enforcement staff and been trained internally. And those are kind of the questions that we came in here today to ask, is to figure out how we can get everybody to talk amongst themselves and then at the same time get an idea of that demographic and what kind of services just that FSBPT could offer. So when formal disciplinary action is taken, which outcome is most common? So in your state, to your knowledge, administratively speaking, are you issuing citations or fines? Education, that was a quick jump real fast. How often are we suspending or putting on probation? So it does look like there's a pretty good component of, you know, rehabilitation and remediation.
Thank you to the people who are putting info in the chat too, because that's helpful for us to look at. One thing while we're waiting for some more people to answer too is, to your point, Jason, talking about the ELDD and communication between states, we also have to make sure we look at what our statutes and rules are. So if you took action against somebody in California for something, that could potentially not be a violation in Oregon. Right. So it could be, okay, this happened in California, but here I'm just going to pull like a CE violation or something
Sure.
that here wouldn't be an issue. At least we still know about it and have a chance to look at it and say, okay, in Oregon, this is not something that would be a violation. Or, you know, is this something that we need to investigate or not? So at least we have the information so that we can decide that.
Absolutely. What is next one? What is the best approach for helping you connect for other investigators and board staff? FSBPT is really looking for what models of communication can they help us form, you know, and so online discussion forums, a list of everybody that we can all rely upon and network on our own. Would a crosswalk of jurisdictional models be helpful to kind of address the issue that Sherry was just talking about, where I may have taken action, but that might not necessarily have been a violation, which happens both ways. I get notifications for things that happen in other states, and then I have to look at it and determine whether or not it's substantially related in California. And so it looks like everybody would be very interested in getting a point of contact form, right? A way for us to kind of reach out and consult with, collaborate with, lean on each other for kind of consultation. And Sherry, in her slide gave her contact information. I'd be happy to talk to anyone from any other jurisdiction that might have a question about any of my licensees or troublemakers that are coming to your state. Just give us a shot and we'd be happy to help with that too. And we have a few minutes left. We're a little bit over time, but I'm willing to stay. I know that my panel members will probably be willing to stay also. Any kind of questions or comments, anything that anybody would like to ask, please feel free. I did see a couple times throughout the chat that there was a question about publishing the information or the outcomes that come from your board's decisions. And so I think as panel members, we can go through it, one after the other. But in California, we're very, pro-revelation. So when you go to verify the license of any of my licensees and they have disciplinary history, their disciplinary history will be part of that licensure verification. So much so that if they have had sanctions or discipline against their license, those documents are there for the duration of their licensure history. You can go back in, you can click into their accusations, you can click into their disciplinary documents, you can see what got them in trouble, you can see what we did about it. It's very transparent, it's very consumer protection oriented. It's there for the purpose of the consumer making that educated decision whether or not they want to go ahead and continue to receive services from that licensee, given those particular circumstances. Citations that we issue stay on our licensee's record for 5 years and then they drop off, but those again are kind of low level infractions, things like continuing education, compliance, and that kind of thing. We also publish our disciplinary history in our seasonal newsletters that we do twice a year. And I know that my licensees have all told me that's the favorite part of the newsletter, right? As soon as they get it, they thumb right back to the end of it to look at the discipline to see if anybody they knew got in trouble. We also put into those newsletters congratulations to everybody that's got licensed since the last newsletter too, because it can't all be bad news. But and then we also put in our quarterly statistics report our disciplinary history since the last or the previous quarter. So if all you're interested in is who got disciplined in California, we make it really easy for you to find. The most important part is if you're trying to determine whether the practitioner that's providing you services got in trouble, that's just part of their license verification. That's even easier to find. You know their name, you know their license number, you type it in, you see the whole history.
Jason,
Sherry?
Thank you. And panelists, thank you. On behalf of the board of directors, I'm here to say that the best presentations aren't the ones where you leave with all the answers. You leave with better and better questions. And if this webinar has piqued your appetite to find out more information about this issue, we've got some fabulous webinars coming up. One tomorrow about emerging areas of practice, and later in November on military spouses benefits, the hows and whys of the NPTE redesign, and new board members and staff preparation to serve. Clearly, this webinar has given me an appreciation for the art and science of what you as investigators do and how hard your jobs are. We need support by coming to other programming to feed us, including the presentations at the annual meeting next week in Jacksonville, Florida. We'd like to highlight just a couple of presentations being given that relate to this topic, including Catherine Caldicott's presentation on the process of the work she's done on sexual boundaries and how regulators can respond, and a very interesting presentation given by Nancy Oglesby and Michael Miner about trauma-informed interviewing. And I can't imagine a more timely topic that would relate to the important work you do. So Jason, no need to be ashamed of your shameless plug. Protecting the citizens of our jurisdiction is the highest calling we have. Thank you for participating on this presentation today. Thank you, panelists. And I look forward to when our paths cross again.